Good morning, everyone. My name is Mitali Negrecha, and I am the head of European networks at Fair Trials. I'd like to welcome all of you to our event this morning, Protecting People's Criminal Justice Rights in the European Union. This event is hosted by Fair Trials and its Legal Experts Advisory Panel, or LEAP. LEAP is a coalition of over 100 criminal defense lawyers, academics, and civil society organizations from across the continent committed to advancing fair trial rights. We are very excited for today's event. I will be joined in hosting the program by my colleagues Laure Baudrier-Girard and Griff Ferris. We are very thrilled to welcome our opening speaker, Commissioner Didier Reynders, who will share his views on the EU's priorities for protecting people's criminal justice rights. We are sure that the Commissioner needs no introduction. Our audience is very likely to be familiar with his efforts on advancing fair trial rights in the European Union. We'd like to thank the Commissioner for joining us and for his support of LEAP over the years. Commissioner, I will now turn it over to you.
Good morning to everyone first, and thank you very much for such an opportunity. I'm very pleased to join you today for this seminar on the rights of individuals in criminal justice in Europe. And I would like to thank the European Parliament and the Fair Trials organizations for the preparation of this event in this particular context. It's better maybe to have a physical presence in the room, but we have now the tradition to work by video. I wanted to participate because I know the continued commitment and recognized expertise of Fair Trials in protecting the rights of people to a fair trial. Your inspiring work helps to feed the Commission's reflections on these themes, and which are at the heart of the European model, and which are also an essential element of the respect of the rule of law. And we will, in some days now, publish the first annual report on the rule of law, and with a specific chapter in all the member states dedicated to the independence of the justice system and the effectiveness of the justice system, but also with some comments on the elements in relation with fair trial. The coronavirus pandemic has highlighted some of the issues that will be discussed today, such as the situation of prisoners or the development of new technologies in criminal proceedings. The Commission is fully aware of this and acts to address the specific difficulties which may arise during this period. And in the report on the rule of law, we'll mention different concerns that we have about emergency measures. But however, as the program of this seminar indicates, the rights of individuals in criminal justice need to be protected beyond the pandemic. The European Commission is monitoring these rights and is open to improving the functioning of our criminal justice systems. We have all been facing challenging times trying to tackle the spread of COVID-19, and prisons are not spared by this threat. On the contrary, limiting the impact of the coronavirus in a closed and vulnerable environment put prison services under a high pressure, and both staff and prisoners are concerned about their health. One of the measures taken to control the spread of COVID-19 was to temporarily suspend all family visits and activities with outside persons such as sport, professional or vocational training. Prisoners were suffering from the isolation and lack of activities, and this measure made it a challenge to keep staff motivated and prevent prisoners' riots. Detention issues are primarily a member state's competence, and the Commission cannot intervene in the management of prisons. However, the EU stands ready to support member states, prison authorities in their response to the COVID-19 crisis by facilitating the exchange of information and best practices via different organizations such as Europris. And we have exchanged information thanks to Europris during the last months. I also discussed the issue at the informal video conference with justice ministers on 6 April, where member states were reminded to resort to non-custodial measures such as electronic bracelets, especially for pre-trial detainees and inmates with low risk profiles and caring responsibilities. So, and we have seen an increasing of the use of other instruments than to put people in prisons. By the end of May, several countries had begun to lift restrictions and restore visits under certain conditions. The Commission will continue to support the Member States to ensure a smooth transition to the new normal. We should take advantage of the lessons learned. Some initiatives that were intensified with COVID-19 should be mentioned afterwards. For example, video calls between children and parents in prison, which should be an addition to the regular presence visits. Member States should continue to work on pressing issues such as overcrowding or the use of alternatives to detention. Let me stress very clearly another issue in relation with the European arrest warrant. I want to be clear that surrender procedures under the European arrest warrant framework decision must comply with all fundamental rights as enshrined in the Charter. One preoccupying issue is poor detention again conditions and the problem of overcrowded prisons in several EU member states. A number of questions concerning the impact of detention conditions on surrender decisions have been clarified by the Court of Justice in the landmark judgment in Arnozi Caldararo and the follow-up cases such as Emil and Dorabantu. So we have no case law from the Court of Justice to try to clarify the situation. We see a very diverse picture where member states have refused or postponed European arrest warrants as additional information has been requested due to poor detention conditions. In the first place, some member states classify particular issuing states at risk, while others do not, and continue executing European arrest warrants originating from those member states. To assess whether there is a real risk of inhuman and degrading treatment, judges also rely on different types of sources. Some take into account reports of the Committee on the Prevention of Torture, others of national bodies monitoring detention conditions, or even make use of newspapers articles. The Commission has requested the Fundamental Rights Agency to develop a one-stop shop database. The Criminal Detention Database combines in one place information on detention conditions in all EU member states. It does not rank member states, but informs about selected core aspects of detention conditions, including cell space, sanitary conditions, access to health care, and protection against violence. The database has been launched in December 2019 and has been discussed yesterday at the German Presidency Conference on the European arrest warrant. We hope that this tool will improve the situation and lead to less divergent assessment of the detention situation in a particular member state. I'm hoping also that it will be a real pressure on the member states to go to a real amelioration of the detention conditions, of course, in different prisons. I also to mention another issue about the pre-trial detention. It's an important debate also at the European level. The issue of detention conditions brings me to this other problem in the application of the European arrest warrant, which is the possibility of long periods of pre-trial detention in the issuing state, which was also mentioned in several resolutions of the European Parliament, including the most recent one, as discussed in Ligue on Monday. It is true that the length of pre-trial detention varies greatly from one member state to another. In some countries, it is a few months, while in some others, it may take several years before the actual trial takes place. A few years ago, we performed a comparative law study, which was finalized in 2016. It turned out that overall, member states' legislations conform to a reasonably high degree with the European Court for Human Rights case law and the Council of Europe recommendations. But in practice, there are significant shortcomings. The services are currently looking more closely into the matter to identify what is needed in this field. And I'm very pleased to receive maybe more remarks and proposals about that, because it's a very difficult debate, of course. at the European level, but we need to make some progress on this. I want now to say some words about the procedural rights. The COVID-19 crisis had, of course, also an unprecedented impact on the procedural rights of suspects and accused persons in the EU. Courts were closed, proceedings delayed, contacts with lawyers were restricted, fair trials report beyond the emergency on the COVID-19 pandemic, based on the information provided by the members, provides a comprehensive oversight of the measures and practices which have been adopted on national level. I fully agree that the fair trial rights of suspects must be ensured also in times of crisis, and the recommendations fair trials formulate provide a welcome contribution to the discussion. Over the last months, our services have also continued their important work to ensure proper implementation of the 6 procedural rights directives. Compliance assessments have shown a number of conformity issues which need to be taken up with member states, if necessary, through further infringement proceedings. Moreover, I wish to continue the reflections on possible further safeguards in this area. Our services will look more closely into possible rules concerning the cross-border use of evidence in order to get more precise information on problems arising with regard to the collection and transfer of evidence in cross-border cases. We will also analyze in further detail the need for more stringent rules for the protection of vulnerable persons in criminal proceedings, in parallel with an analysis from the civil law perspective. Although discrimination on the grounds of racial and/or ethnic origin is prohibited in the European Union, such discrimination is still widespread in our society. Regrettably, racial discrimination also persists in law enforcement and criminal justice systems. I'm aware that this may have a considerable negative impact for suspect and accused persons who are confronted with racist behavior and decisions by police and law enforcement authorities, or decisions by prosecutors, judges, or courts on arrest or pre-trial detention, sentencing decisions, and penalties imposed. In the field of procedural criminal law, the Procedural Rights Directive and the rules on victim rights provide for minimum standards to strengthen the rights of suspects and accused persons in the rights of victims of crime. These directives should be applied in accordance with the principle of non-discrimination, meaning that any discrimination based on any ground, such as sex, racial, or ethnic origin, is to be prohibited. Further action on EU level and national level is required to find racial discrimination and to ensure that progress can be made quickly. That's why, very recently, the Commission has presented an EU action plan against racism for 2020 to 2025. This plan provides for a range of actions by the Commission itself, and where the Commission encouraged member states to take the necessary steps to combat racism and discrimination. All relevant actors are invited to engage in an open dialogue to help inform the further development and implementation of policies to counter racism. The Commission invites also the European Parliament to regularly discuss and support the implementation of the action plan. The recommendations of fair trials are very welcome and highly topical in this context. I want also to say some words about the use of new technologies, digital technologies, and maybe artificial intelligence in justice. Digitalization has significantly changed people's lives and ways of communication in recent decades, and will continue to do so. This pandemic has given a further important push to it. Modern technology has provided many of us with the possibility to work from home, our children and students to follow online lessons. As the President of the European Commission underlined recently in a speech on the State of the Union, we must make this Europe's digital decade. This increasing importance of digitalization in modern society has a large impact also on our justice system, including the area of civil and criminal justice. Our services are currently looking more closely into the opportunities digitalization offers for justice in the European Union, but also into associated risks and challenges. My objective is to present the outcome in a communication before the end of this year. And we will discuss the digitalization of justice in the next Justice Council in Luxembourg at the beginning of October, again with all the Ministers of Justice from the Member States. As regards artificial intelligence, the Commission has presented its white paper in February this year and launched a vast public consultation which solicited a large interest and participation by various stakeholders. The use of AI and AI tools may facilitate the logistics of administrative and judicial procedures or the discovery of relevant information. The use of such tools becomes, however, highly sensitive when AI is being used either to assess or estimate future human behavior or as part of the decision-making process. Especially in the criminal justice systems, sufficient safeguards are needed to guarantee the protection of fundamental rights and to ensure a responsible, human-centric development and use of artificial intelligence tools where their use is in principle appropriate. The right to a fair trial and to a legal remedy, the principle of presumption of innocence, and the right of defense of suspects and accused persons, as enshrined in Articles 47 and 48 of the Charter, and in secondary EU law, notably the Procedural Rights Directives, may not be undermined by the use of AI tools. I also consider that judgments must only be delivered by judges who understand the system they use and all information that they take into account so that they can explain their decisions. While the prevention of crime or an improvement of quality of criminal justice judgments are certainly goals we all share, the risk of bias and discrimination against particular groups are high, and mass surveillance with the help of AI systems in facial recognition tools poses a threat to open and pluralistic societies. The reflections and recommendations of fair trials in the paper regulating artificial intelligence for use in criminal justice systems in the EU are excellent food for true and will be a highly valuable contribution to the discussion in the follow-up to the Commission's white paper on artificial intelligence and any possible European regulatory framework. So I thank you for the different reports that we have provided. Thank you also for this opportunity this morning to say some words about the different challenges. I would just to insist on the last point. I said that we will communicate on the first annual report on the rule of law next week. We will debate it at the college level, and beginning of October, maybe on the 5th of October, we'll organize the communication to the public on this report. But I'm very interested to continue the work, not only in the European Council with the General Affairs Council or in the European Parliament, but also at the national level. And of course, with the help of a lot of participants in your conference today, it will be easier maybe to try to install a real culture on the rule of law in the different member states and to discuss again the situation in our justice system, the independence, the efficiency of the justice system, but also the way to organize fair trials. And I want to add all the time, of course, we need to organize a fair trial for the suspect persons, but also for the victims. And you know that we have launched a new victim rights strategy, so it's also an important part of the debate. But thanks again for this opportunity. Thanks for your attention, and I'm always open to receive remarks and comments at the end of your conference. Thank you very much.
Thank you very much, Commissioner Reynders. My name is Laure Baudry-Gérard, and I'm a legal director for Fair Trials Work in Europe. And I'd like to start by thanking you, Commissioner, very much for taking us through the Commission's promising agenda on EU criminal justice. Thank you very much as well for your kind words about our work, and we're grateful for the Commission's long-standing support of our work, of the Ligue network, making events such as today possible. I'm very pleased to hear you've highlighted the impact of poor prison conditions on judicial cooperations and the different initiatives that the Commission has taken in that respect. We also very much welcome your call for progress and input on what can be done around pretrial detention and limiting its overuse, and also the recognition of discrimination in criminal justice system, something that needs to be tackled. It's also a great pleasure to see that so many of you have tuned in today for a discussion about the future of EU criminal justice, because we all need to care about criminal justice more now than ever in these uncertain times, when we're seeing rule of law backsliding and fundamental rights being forfeited in the name of cost savings and the name of efficiency, and where states once again have turned to criminal justice systems to address societal problems, this time the COVID-19 health crisis. But criminal justice measures are incredibly powerful and potentially destructive of people's lives and everyone's rights and liberties. And that's why we're very excited to hear the Commission's plan, and we call for urgent EU action at a regional level to address the three specific issues that we want to cover today. First, the need for the EU to tackle the long-standing issue of overuse of pretrial detention, that immense power that states have to lock up someone who is presumed innocent, to lock them up for days, weeks, or even years, as Commissioner Reynders highlighted, to lock them up before any court of law even finds them guilty. And in Europe, we're talking about 1/5 of our prison populations. So just today, that's 100,000 people who are held in pretrial detention. Second, the need to recognize another long-standing issue, but one that's simply been ignored for too long, is discrimination in our criminal justice systems, which has been leading to an overrepresentation of racial and ethnic minorities in our prisons, as well as poor people. And third, we welcome the EU taking the lead on setting standards over the use of technology in criminal justice systems. We need to make sure that the use of these new tools, particularly artificial intelligence, which is used to predict who will commit a crime before anything actually happens, doesn't lead to further curtailments of rights and to further discrimination. But before our three panelists address these issues, we're honored to welcome as our keynote speaker today, MEP Dr. Pierrette Herzberger-Fofana, who has, amongst other roles, the role of a co-president of the European Parliament Intergroup on Anti-Racism and Diversity. Prior to being elected to the European Parliament, she was a city councillor in her hometown of Erlangen in Germany, where she also served as a lay judge in the district juvenile court. Her main areas of focus are anti-racism and non-discrimination, and we're delighted to hear her vision for EU criminal justice today. Thank you very much. MEP Dr. Herzberger-Fofana, c'est à vous.
Thank you very much. Merci beaucoup. Thank you very much. Good morning, everyone. Dear guests, dear Commissioner, I am honored to be here to discuss this important topic with you all today. Many thanks to Fair Trials for this invitation. Altiero Spinelli, a founding father of the European Union, wrote a treatise against pre-trial detention and imprisonment in 1948. He argued that pre-trial detention should be short and incarcerated people should be accompanied by their friends and family instead of being placed in detention together. He also reasoned that prisons serve only as, I say, quotation, schools for vice, and that the idea of such institutions being places of moral redemption is a hypocritical notion. These are ideas I would like for us to consider today. Sorry. For 7 years, I was a lay judge in the local juvenile court in Erlangen in Germany. I sat with the judge, listened to cases, and gave my opinion on the sentences to be passed. Erlangen is an affluent town with a predominantly white population. The majority of young people that passed through the court were middle-class white children, and we rarely handed down prison sentences. Instead, when young people would be given community service, working in retirement homes or street cleaning crews. The effect was profound. Recidivism was very rare. Here I saw the benefit of alternatives to detention, especially when dealing with juveniles. Furthermore, I learned to question what we call a crime and how we deal with the accused. Discrimination in my second point would be the discrimination in EU criminal justice systems. Our current criminal justice system is a system that we know to be flawed, a system rooted in violence and discrimination from its inception. Many of police forces and prison systems we know today were established to protect the interests of colonizers and feudal overlords. As such, perhaps we should know more over the existence of discrimination in such a system, but rather we should think about whether or not such a system is capable of helping us to address the existence of harm in our society. Nevertheless, I will discuss the present issues within the system as they exist today. Discrimination within the criminal justice system affects people at every level. A study by the Justitia European Rights Network demonstrated that Black, Asian, Roma, and African minority people are most vulnerable to discrimination in the course of criminal proceedings, and that institutional bias fosters disparities within criminal justice system. We often, and rightly so, focus on the discrimination perpetuated by police forces. We must also address the consequences of that initial bias. In France, according to a report from the Defender of Rights, men perceived as Black or Arab are 20 times more likely to be subject to a police control. This means a number of things: that they are also more likely to be charged with a crime, more likely to be sentenced, and more likely to spend time in prison. The Lemire report shows that in the UK, people from ethnic minority background are more likely to receive harsh sentences than their white counterparts. In Bulgaria, people with Romani background accounted for almost half of the prison population, according to a survey by the Bulgarian Helsinki Committee. And in Romania, people with Romani background face discrimination even from the lawyers that are supposed to represent them. This discrimination is also clearly present in the application of pre-trial detention, which, although it is a measure that should be used only as a last resort, accounts for almost 20% of the total prison population in the EU. Non-nationals and people from ethnic minority background are disproportionately represented in this number. In various member states, a lack of social networks, family, and access to permanent housing mean that these groups of people are more likely to be placed into pre-trial detention. Despite the facts and figures that I have highlighted just now, it is also important to note that there is no clear and consistent collection of data on criminal justice disaggregated by racial and ethnic origin in the EU member states. This must change. Such data is necessary not only to quantify the scale of the problem, but also to measure any potential improvements. The EU is well aware of these issues. The Action Plan on Racism, which is now known, last week from Mrs. von der Leyen, unveiled by the Commission, discusses the need to counter such discrimination by law enforcement authorities, namely through comprehensive training package and the promotion of good practices. However, police, judges, and other members of the law enforcement society already receive such trainings. The EU spent 78 million on its justice program between 2040 to 2020, of which roughly 34% went towards training. Unfortunately, available statistics on discrimination suggests that something is not working. Rather than sticking to business as usual, we must strive to develop new innovative approaches towards countering discrimination within the criminal justice system by moving away from things that we have always done. We should invest money in tackling the root causes of discrimination within our society in general. Police, judges, lawyers, and the like are all products of their environments, and we must work to change these environments. The EU should continue to encourage member states to consider alternatives to custodial sentences, such as some of those highlighted in the Council conclusions on alternative measures to detention of December 2019. For example, facilitating the development of restorative justice and exploring community service and suspended sentences. Furthermore, it is not just in the area of criminal justice that alternatives to detention should be considered, but also in the area of migration, especially given that the disappointing migration pact unveiled on Wednesday only increases the likelihood of the detention of asylum seekers. The COVID-19 crisis showed us that such alternatives are possible, at least when the political will is present. Lockdowns meant further restriction of the already limited rights of prisoners. Overcrowding and the lack of resources led to a strain on already terse prison system and immigration centers. As a result, a number of member states sought to ease the consequent pressure by instituting alternatives to detention, both in the criminal justice system and the immigration detention system, raising questions as to the necessity of detention. We must continue to ask those questions. I was asked to outline my vision for EU action on criminal justice. My vision borrows from the ideas of Mr. Spinelli. I hope that we will move beyond the discussion of discrimination within existing criminal justice systems and towards a dialogue on the benefits of said system to our societies. That the EU will encourage member states to rethink the current iterations of their criminal justice system in their entirety, to question the utility of detention and to consider real alternatives, ones that contribute to reducing the existence of survivors rather than punishing perpetrators. Thank you for listening to me.
Thank you so much, Dr. Pierrette Herzberger-Fofana, for those very, very inspiring remarks. I want to especially thank you for centering our discussion today on issues of discrimination. and so thoroughly going through the details of how we should be thinking about these issues. As we mentioned at the outset, we will now turn with our three speakers to looking in more detail at our priority issues for EU action in the coming years. The first issue we will turn to is one that has come up now a few times already this morning, the problem of Europe's very high pretrial detention rates. I will not repeat what it is that the Commissioner and the MEP and Laura have already put on the table, but just to reiterate briefly, the human toll of pretrial detention. Recent research has highlighted that even one night in jail has serious consequences for people's future life outcomes, including their ability to access housing and employment. As Dr. Herzberger-Fofana also mentioned, we know that there are disparities in pretrial detention such that people of color are held more often. The link between high pretrial detention rates, mutual trust and recognition in the EU, and prison conditions were highlighted by Commissioner Reynders. And these issues have been at the forefront of judicial decision-making in France recently. I will turn then the event over to Constance Ascione, who is a criminal litigator, based in Paris, France. Constance specializes in white-collar crime, complex and transnational criminal litigation. She's been practicing law since 2013 and also teaches at Sciences Po Law School. Constance will talk to us about her perspective as a lawyer on pretrial detention, and in particular, why it is that member states alone cannot be asked to reduce pretrial detention rates. With that, I will turn it over to Constance.
Thank you very much, Mitali, for this very kind introduction. Thank you very much to the previous speakers, because we're now very familiar with all the hot topics related to pretrial detention. And I think when examining this question of pretrial detention, there are landmarks and tensions that we really need to bear in mind. And I'd like to share with you this slide. There we go. So my purpose here is absolutely not to give a lecture, obviously, but to share with you some thoughts and some ideas. And I think when looking at pretrial detention, we need to bear in mind, probably first and foremost, the need to protect presumption of innocence, because as Mitali pointed out, all those suspects and accused being detained all over the European Union, even at this very day, are all presumed innocent. And this is not a theoretical concept. It's for you, it's for me, it's for your uncle, my best friend. We want to preserve and protect presumption of innocence, which is why it should be a measure of last resort when there are no other alternatives. But there's also the conflicting tension of protecting society against individuals, which is related to this issue of fear, collective fear of individuals, of criminals, because suspects and accused, while being on bail, might commit further offense, and there's a duty by the state to protect society. This is also related to headlines and media coverage. I'm sure you've all seen in your member states cases where a suspect or accused was being released on bail and committed a further offense, and then the headlines would point the finger at the judge, and public opinion would be outraged that the person was not remanded into custody in the first place. So this is related to the trust that citizens should be able to feel for the justice system. They should be able to trust the system. But then again, this is in tension with protecting individual rights, the rights to come and go, obviously, but also family rights, as Commissioner Reynders very rightly pointed out, which are key to society and which are also the root of our social contracts. We believe and we trust our state systems because they use physical force and physical constraints in a legitimate way. And so if we move too much in that direction, then we break the social contract. And it's what we're seeing with the Black Lives Matter movement, when we feel that individual rights are not being protected by the state, and on the contrary. But then again, there is the conflicting issue of solving cases and punishing crimes, which is also a duty by the state, because the suspect or the accused might impede criminal investigations. He or she might threaten the witnesses or pressure the victim or try to lie with co-accused, so on and so forth. And last but not least, I think, is the issue of costs, because pre-trial detention is costly. In France, we have this figure, which is not very reliable, but still it's useful for our debates. So pre-trial detention would cost approximately 85 euros per day per detainee, which is kind of a good budget if we want to try and think about alternatives. So bearing in mind all this, I will try to briefly touch upon 3 points, and bearing in mind also that I am necessarily biased, that I'm probably forgetting lots of tensions, landmarks. I'm giving my view as a criminal defense litigator based in France, and I'd like to share with you why I think there's a problem with pretrial detention in the EU, then why the EU should care and act, and what could the EU do. So first, do we have a problem with pretrial detention in the EU? And I think the short answer to that is yes. And I don't intend to linger much on that. I can recommend that you read Fairtrial's excellent report, A Measure of Last Resort, for instance. But I'd like to share with you the French perspective, not to point the finger at France, but just to have a look together at the practical implications of abuse of pretrial detention. So I think the first issue at stake here, which was pointed out by the previous speakers already, is that of prison conditions. Why? Because it's a vicious circle. We have too many pretrial detainees, so our prisons are overcrowded. Right now, as we speak in France, there are 20,000 people being detained in our prisons, pending trial, so still presumed innocent. So our prisons are overcrowded, and so our prison conditions deteriorate, our prisons get completely dilapidated, and then we put more people in detention, more prisoners and more pretrial detainees, which are exposed in turn to inhuman and degrading treatments. So this is exactly what's happening in France. So it's not a theoretical notion here. So interestingly, so to speak, most member states have already been found in violation of ECHR case law by the Strasbourg court because of prison conditions, and in particular with respect to the prohibition of inhuman and degrading treatments. In France, we had one very strong decision in January this year, on 30th of January. So the court had to examine an application by 32 French prisoners, and the court found that they were indeed being imposed inhuman and degrading treatment. And the court noted, for instance, that for some of them they had less than 3 square meters in the cell to live, that for some of them they had no privacy when going to the toilets, for some of them they had no activity outside the cell, so they would stay in their cell 24/7. So the court ordered France first to improve its prison conditions, but also to provide effective remedy to these prisoners so that they could be protected against inhuman and degrading treatment. The answer to that was given by our Supreme Court, the Court of Cassation, la Cour de Cassation, on the 8th of July. So existing case law by the French Criminal Court was that, by the French Court of Cassation, was that pre-trial detention matters, yes, this is one criminal proceeding, and then the issue of inhuman or degrading treatment should be dealt with in other proceedings, administrative proceedings, and prisoners could sue the state to get damages. But pre-trial detention and prison conditions had no link, and it was not a legal ground for pre-trial detainees to be released on bail. Now, based on the ECHR decision rendered in January, in July this year, the Court of Cassation said, no, pre-trial judges and judges in general, when having a look at pretrial detention, should take into account prison conditions. And if prison conditions are unfit, and if people are exposed to inhuman and degrading treatment, they should be released immediately. Now, that's excellent news, and it's a very good example of EU and Council of Europe good influence on member states. there are obstacles to be overcome. And in my experience, some days ago, I filed an application with a judge for one of my clients to be released on bail, and I pointed out her very, very bad prison conditions, and the judge did not even answer to that point, because she still thinks that none of this should be her concern. And now we know that it should be her concern, and this is good news, and we all need to get familiar with that useful tool to protect our detainees against inhuman and degrading treatment. So that was just to give you an example of the very sad relationship between pretrial detention and unfit prison conditions. Now, another very negative impact of pretrial detention and abuse in pretrial detention is mutual trust, because in relation to those very poor prison conditions and abuse of pretrial detention, we had an answer by other courts, and I'll give you the reference here. So we had a decision by the UK High Court, which suspended execution of French European arrest warrants in July this year, pending information to be given by the French government on prison conditions and on the measures taken by the French government further to the ECHR decision. A similar decision was also taken by the Amsterdam court in September this year, and I expect that other member states are probably going to do the same. So abuse of pretrial detention also impacts and impairs mutual cooperation, and this should not be taken lightly. So I think we all agree that there is an issue. Now, why should the EU take action? And I would like to share with you this excellent quote from the roadmap, the 2009 EU roadmap for criminal procedural rights, because I think everything is here really. Excessively long periods of pretrial detention are detrimental for the individual, can prejudice judicial cooperation between the member states, and do not represent the values for which the European Union stands. This is why the EU should act. The EU should act because we have values. We believe in democracy. We believe in social cohesion. The EU should act because the EU promotes and protects human rights, dignity, freedom, presumption of innocence. And the EU should act also because of judicial cooperation, which is so important for the Union and so meaningful. And I can add two other good reasons to that. And I'm sure you all have good reasons for the EU to act, because we know that it works. We've seen it with the roadmap directives. We've seen that the EU can really give the states incentives and recommendations that really effectively improve human rights within our criminal justice systems. And also because we have a formidable laboratory of 26, 27 member states to explore this notion, to try and find solutions, to try and identify good practices and to spread them around. So yes, the EU should act. And so what could we do? So there is one interesting and I think probably key notion, which is that of time limits. And I can recommend the excellent work of Professor Thomas Smith from the University of the West England on the impact, notably in England and Wales, of custody time limits on pretrial detention and pretrial detention rates. But I think if we go further, we could try and set up a kind of EU observatory for pretrial detention. What would this observatory do? I think probably various things. Just moving on again to that PowerPoint. First, I think the observatory could monitor, study, and assess pretrial detention. In France, we have a commission that's supposed to be in charge of that, and very sadly, they published a report in 2016, and they start by saying that their mandate was to produce yearly reports, but they don't have the means. So they publish it every 2 or 3 years, and they don't have the means to publish and to share their findings. So I think we need to question pretrial detention. We need to assess, we need to have a look at it so that it doesn't remain in darker areas. We also need to identify best practices, and the EU Observatory could do that based on 26 different practices across Europe. The EU Observatory could also provide information and practical tools on alternatives, because it's easy to point the finger at our judges and think that they order too much pre-trial detention if we don't give them reliable, reassuring alternatives. It won't work. Electronic tagging is only one of them, maybe information on the European supervision order, etc. And then the observatory could also try to disseminate knowledge and establish a shared culture between practitioners with training programs, with yearly conferences, with seminars such as this, so that we all discuss this issue and we change our culture from too much detention to release and freedom in general. So yes, there is a need for the EU to act and to react, and there are easy things which could be done so that pretrial detention really protects society, but not by damaging human rights.
Thank you so much, Constance. The second issue that we will turn to today is the problem of racism throughout our criminal justice systems. Starting in June of this year, and inspired by the protests in response to the murder of George Floyd by the police in the United States, tens of thousands of people have come out to the streets across Europe. These protests were in solidarity with the US, but also raised issues of discrimination in policing across the European Union. As the Commissioner mentioned, the Commission has started work on a strategic action plan against racism. That action plan today includes some efforts to counter racial and ethnic profiling in policing through trainings and data collection. Today, we will consider what more the Commission and the Parliament can be doing on issues of racial discrimination throughout criminal justice systems. We know, for example, and some of this data was shared earlier, that people of color face worse outcomes once in criminal justice systems in Europe. We know that poor neighborhoods and neighborhoods of color are subject to increased policing and surveillance, which then means that people of color and poor people are the ones that end up in the criminal justice system. We also know that there's considerable scope for our societies to think of responses that are not punitive. Today, we will look at these issues through one case study. Our next speaker, Pierre-Arnaud Perrouty, is the director of the Human Rights League in Belgium. Pierre-Arnaud is a lawyer who specializes in human rights with a focus on civil liberties, equality, and diversity. His organization, during the COVID pandemic, looked at how policing of the COVID crimes was targeted at or disproportionately impacted minority communities. He will tell us about that research and the impact of fines and policing on those communities. With that, I will turn it over to him. Thank you.
Thank you very much, Mitali, and hello to everyone. And thank you to Fair Trials for the opportunity to share the main findings of our report and our work in general. So maybe a brief word of context before going into the report. The Human Rights League in Belgium decided to set up an observatory of police violence back in 2013. So it's 7 years ago. And after a few initial reports, the project had been relatively dormant until last year, where we received a good deal of testimonies in the context of large demonstrations, mostly in Brussels, around the Yellow Vests movement, but also about climate action demonstrations. And in many instances, there were reports made of unnecessary and disproportionate use of force by the police. This is, of course, not limited to Belgium. If I look at our neighbor in France, we know there are many instances of police violence during demonstration, but that happened, of course, in other member states. So that led us to redesign the website and to call the project Police Watch, with three main objectives. First, to inform citizens of their rights regarding police, because it's very known that people have a very vague idea of what the police can do or cannot do and what they can do while interacting with police forces. Secondly, this website was meant to collect testimonies, and that's very important. Testimonies both from victims or people who are witness of police abuse, and to produce analysis from those testimonies. And thirdly, of course, to engage in advocacy work, both with police authorities, but also with public stakeholders or politicians, or generally any stakeholders around these issues, as we know that many people are involved somehow in the fact that the impact of the police on the ground is somehow to be found again later in the chain of the criminal justice in general. Now, coming to the report, the new website was launched in March at the very same moment where a general lockdown was decided on Belgium. So of course, due to the COVID crisis, most of the testimonies we got through this website were somehow linked to the lockdown, not in the very first days or weeks, because there were very few interactions with police, of course, as people were stuck home. But as the measures were modified, people started to go out, and more interactions with the police were taking place. So we produced this report called Abus policiers et confinement, so police abuse and lockdown, based on testimonies received directly through the website, but also from partner organizations and also from institutions like UNIA, for instance, which is the national equality body in Belgium, which received also testimonies and complaints from citizens regarding police action. So what does the report tell us? First of all, that there was a real problem with the vagueness of the measures adopted around the COVID crisis, and that did create uncertainty about what was allowed and not allowed on the ground, especially in a city like Brussels, where you have municipalities that could also take specific measures in their precinct, in their commune in Brussels, which meant literally that sometimes you didn't know precisely what you could do or not do, and it was changing from one commune, one municipality to another, from one street to another in Brussels. So people were changing commune, municipality without even knowing it, and different rules could apply. And that was a problem, of course, not only for the people, but also for police officers on the ground who were supposed to enforce rules that sometimes they did not really understood, or that were changing so rapidly that they just didn't know. So this is clearly against the requirements of legality and enforceability of criminal rules. As we know that people need, of course, to understand clearly what is permitted or not under criminal law in order to abide by the rules. So the immediate impact of that was that many people got fines, and we're talking about fines of 250 euros. So for many people, it's a lot of money, especially for young people. And young people were clearly overrepresented in the number of people who got fined. And in some instances, in some testimonies, we have families who had 2 or 3 fines over 3 weeks of 250 euros. So again, there is a clear and vast disproportion between what they actually did or did not, and the amount of money that was inflicted on them. So turning to the type of abuses that were reported during the confinement, the lockdown, many people reported being beaten during their arrest. That is up to 30%. The arrest was perceived as unjust in 33% of the cases. Well, you could say this is a perception, of course, not many people like to be arrested, but if you go beyond the figures, there is a clear lack of motivation for many stop and checks and arrests, so that there is an issue behind that, and of course the fines, too many fines, too expensive, and so people generally felt that as very, very unjust. It is also worth noting that many people did not initially report insults by police forces because they thought that it was such a common practice that it wasn't really worth mentioning in a complaint or a testimony. This is, of course, not to say that every police officer are insulting people on the ground, certainly not. But we also know that it's too much of a common practice, and that it usually stays under the radar So in most cases, it is unreported. As to who is most likely to endure police abuses, there are mainly 3 criteria, and this is obviously nothing new, but the COVID crisis highlighted it very clearly. And in a nutshell, it is being poor, being young, and being perceived as of foreign origin. In 70% of the report abuses took place in poor areas. This is true for Brussels, but also generally speaking in the country. 56% of the abuses concerned people between 14 and 30 years old, 50%, and that goes up to 70% under 35 years old. So the younger you are, basically, the more you're at risk to get abused by police. And interestingly, also 53% of the people felt they were discriminated against, meaning that there is a bias by the police officers. They think they were of foreign origin, even though they were Belgium in most of the cases. But the fact that you are perceived from foreign origin is a factor of risk. Again, nothing new, but if you combine these 3 factors, so young people in poor areas of foreign origins, they were the first target of police abuse. Now, the problem we had with presenting the findings of the report was a strong denial by some political figures and some police trade unions who denied the very existence of police violence. One of the key arguments is, of course, to refer to the low number of official complaints, to the official complaint bodies, to deny or minimize the problem. But as we know, of course, the fact that people don't file complaints doesn't mean there's no problem. It's just because people think this is useless, this is pointless, it will lead to nowhere, or because people don't know how to file a complaint or where to file a complaint, or a fear of maybe it will be expensive, or maybe there will be some sort of retaliation. So the key point is that in most of the cases, people don't lodge a complaint. Now, turning briefly to the recommendations we made. First of all, and I heard that from previous speakers, this is very obvious, authorities need to acknowledge the issue, the problem, and it's a necessary first step, not sufficient, but necessary. The issue is police violence and ethnic profiling. And to analyze that, we also need official figures and statistics. We know that in some member states, police or the government produces such figures, like in the UK, for instance. But in Belgium, you don't have such numbers of figures or statistics, which makes it very difficult to analyze and to compare and to tell. I mean, very often journalists ask us, is this phenomenon increasing or not? And it's very hard to tell because we don't have figures. In this, the EU could certainly produce some imposition, or at least ask member states to produce figures that would be comparable from one state to another. So that's the first thing, acknowledge the issue. The second thing is to register control by the police on the field, find some way to register. It can be very easy and technological as well. There are applications that use on smartphones that makes it easy and simple. And it's very important to produce against statistics, and in places where it has been done, like in Spain or England, in the UK, this sort of recording has shown issues that even police authorities did not really suspect it. So it's a very important tool also for the police itself. The third thing that is important for us is to reaffirm the right of citizens to film police while in action. It's very important because in most cases of police abuses, where they become public, when they are successful in court, it's because we have images. Without images, you don't have a George Floyd case, you don't have a Chovanec case for those who follow the Belgian actuality news. So it's the right to film the police in action. We're talking about police in action on the public the ground, of course, not while taking a coffee with their wife before going to work, is very important. And it's very important because in some member states, including in France, you have prominent political figures that try to stop that, to make it punishable criminal to film the police and to show the images. So that's mostly it. And the fourth point is to develop better complaint mechanisms, because it's quite complicated, at least in Belgium. You don't have a single entry point. You have at least 3 bodies that are different, but people don't know them. They have a problem of independence. So it's that there is certainly something to ameliorate in the complaint mechanisms. So I will not be much longer here. I'm aware that it's a very much more focused point than the previous speakers, but I hope it can give you some insights of the problem. Thank you.
Hi, good morning, everyone. I'm Griff Ferris, a legal and policy officer at Fair Trials based in London. Thank you very much, Pierre-Arnaud, for sharing such important research on the clear discriminatory trends in policing during the COVID-19 pandemic. It's clear that due to a lack of the widely collected data on ethnicity in policing and criminal justice, such structural discrimination often escapes scrutiny and the necessary action to challenge it. So I'm going to briefly introduce and talk about the concept and issue of artificial intelligence in criminal justice. Artificial intelligence is a term which is broadly used to refer to machine learning or algorithms and other analytical and automated decision-making systems, which have become an important aspect of many of our lives, even if sometimes we're not always aware or don't always realize as it's occurring behind technological closed doors. But in recent years, this technology has increasingly been deployed in criminal justice systems around the world and Europe, playing a growing and significant role in the administration of justice in criminal cases. However, there are significant and fundamental issues with the use of artificial intelligence and automated decision-making systems. These systems have been shown to directly generate and reinforce discriminatory and unjust outcomes. As has been discussed and publicly acknowledged just this morning by Justice Commissioner Reynders and discussed in detail by Dr. Herzberger-Fofana, structural racism and other forms of discrimination are a fundamental reality in policing and criminal justice across Europe. These biases are reflected in criminal justice data. Criminal justice data and the records taken by police do not represent an accurate record of criminality, but merely a record of law enforcement or policing, the actual actions, crimes, locations, and groups that are policed within society, rather than the actual occurrence of crime. To repeat an example given earlier, criminal justice records reflect the fact that Black people are stopped and searched by police at much higher rates than white people. Or, as another example, property crimes such as theft are much more heavily policed, and those involved in them are therefore disproportionately represented in police records than, for example, white-collar financial crimes, despite the fact that such financial crimes often have a bigger impact at an individual and societal level. It is this data, these criminal records, within which these biases are represented, which are used to build, train, and operate the artificial intelligence and automated decision-making systems used in criminal justice. Therefore, criminal justice data reflecting such social inequalities and discriminatory policing patterns, when used in these AI systems, will merely result in a reinforcement and re-entrenchment of those inequalities and discrimination. These systems are used to predict, to profile, and to assess risk, generally attempting to predict whether people will commit crime before they have actually done so, based on that criminal justice data. These systems clearly engage and infringe fundamental rights, including the right to a fair trial, especially the presumption of innocence, as well as privacy and data protection rights. Fair Trials is extremely concerned at the increasing use of these systems and, as mentioned, has set out detailed recommendations to the EU Commission. And we're very pleased to hear Commissioner Reynders like the sound of our proposals. But given the extremely serious risks of these systems, strong regulatory frameworks are needed to govern the use of AI in criminal justice decision-making, and in some circumstances, to restrict its use entirely. However, existing legal frameworks, such as the EU procedural directives, including on the presumption of innocence, and data protection laws, do not currently provide the required adequate protection. We need the EU to take decisive action on the use of AI, machine learning, and other automated decision-making systems in criminal justice, as if they are not subject to proper regulation and oversight, and in some cases banned outright, they threaten fairness and justice. And far from expanding human potential, AI will amplify and worsen the worst aspects of our society, including inequality and injustice. Fortunately, this morning, we have someone who can speak to these challenges and the solutions needed. Sarah Chander leads European Digital Rights, EDRI's policy work on AI and non-discrimination with respect to digital rights. Previously, she worked in advocacy at the European Network Against Racism on anti-discrimination law and policy, intersectional justice, state racism, racial profiling, and police brutality.
Thank you very much, Griff, for the introduction, and also thank you everybody for your wonderful speeches so far. EDRI, I represent EDRI today, which is the European Digital Rights, which is an association of 44 civil and human rights organizations across Europe. We defend rights and freedoms in the digital environment. I've been asked to speak today about the uses of AI in the criminal justice system insofar as they operate today in Europe. The harms that might pose, but also the specific discriminatory impact and implications they might have for racialized people in Europe. But just before I do that, I would just like to commend the organizers and also the speakers of this event. So often we focus, when we speak about discrimination in the criminal justice system, on proving it. We need to prove that it exists. Although I think data, the question of data and the question of understanding what is the evidence that exists for discrimination, I think this is a global moment and also a global movement where we also need to come beyond this need to prove that such systems have a substantial racially discriminatory outcomes. This is by now beyond proof, and I'm really glad that this event took that as a starting point for which we can move forward. We don't have to question it anymore. Although we might need evidence, we cannot take this need for proof for granted anymore. Going beyond to AI and the use of AI in these systems, we have to take a consideration and analysis of how AI is used in the criminal justice system in that context. We cannot hope that just because of the application of technologies to such already discriminatory systems, we cannot hope that such discrimination disappears because of the presence of an algorithm, a computer, or a complex decision-making system. In fact, we might have to question for ourselves how far this makes it worse, particularly due to some of the things Griff already mentioned, the transparency, lack of transparency of these systems, how they work, but also when they are being deployed. A major issue that many digital rights and also anti-racist organizations are currently finding themselves in is actually knowing when such systems are procured and deployed by their justice systems, finding out the adequate information that these systems are actually either being trialed or in operation, but also understanding, okay, so if they are being in operation, how do they work? How do the outcomes that they produce impact people in terms of their day-to-day experiences with the criminal justice system, in terms of policing in pre-trial, but also in later stages? And then lastly, how might we contest that if we disagree with the application of such systems? How might we, as people that are subject to the criminal justice system, how might we have a say in whether or not we believe that these should apply or not. All of these are really open questions as AI in the use of the criminal justice system. We are very at the start of understanding some of these things. We have heard many stories from the use of such systems in the US, but we are, in terms of Europe, we have a very limited understanding of how they work. So all of that is some wider context for some of the things I will say today. I would like to speak specifically to the use of predictive policing systems, but I think we have to take such systems in a wider context of an increased resort to systems of mass surveillance and identification techniques using biometric data, so such as facial recognition and speaker identification, also risk assessment algorithms, all of which sit in combination with and underlined by the development of highly opaque police databases and matrices gathered to collect data on suspicious individuals, the potential perpetrators of crime, which I think we think pose severe threats to privacy for everybody. But one concern in particular is that many of these developments will have negative implications, in particular for racialized groups and communities. And it was spoken of before that we have to look at AI in terms of their massive potential. And this is a huge discourse for much of the governance conversation around AI. We have to look at the potential of AI in all areas, the criminal justice system, the migration system. And whilst this is so often said, I think, I will reiterate Laura's point earlier, that often all of these techniques are promoted as cost-saving efficiency measures, but often these are presumptions of benefits. We don't have sufficient evidence that these actually are working, useful, and non-discriminatory. And for that, we need a greater level of public consultation, public oversight, and transparency of how actually these systems use, and actually do they give the benefits that they say that they will give. Going a little bit deeper into how some of these systems operate, we do see increasing evidence which demonstrate how such new technologies in the field of law enforcement differentiate, target, and experiment on communities at the margins, even where we have seen some examples of predictive policing systems and other systems where predicted identity markers and classes of information are removed from given data sets, such as race and ethnicity. We still see that discriminatory outcomes nonetheless arise. I will focus specifically on predictive policing systems where we have seen some examples of trials at the local levels in the Netherlands, Germany, Switzerland, Belgium, the UK, and many other countries. And what these systems actually are the use of technology to forecast where and by whom a narrow type of crimes, often theft, petty crimes, or crimes derived from situations of inequality or poverty, to predict where these crimes are likely to be committed or by whom. And I think this is a really important question. This notion that we can predict who will commit crime or by people in which areas can commit crime is a very racially infused notion. The idea that we can know by someone's circumstances and very arbitrary circumstances where they live, or in effect what type of identity category that they belong to, whether or not they will be a potential perpetrator of crime, is a very tricky, and I would think we should have a lot of criticism for this very notion. The research that exists so far shows that you can have place-based and you can have person-based predictive policing systems. Some of those tests that have undergone, and this is evidence in Fair Trials research, it's also outlined in some of EDRI's case studies that we've looked into. Some of those systems directly use factors such as ethnicity or nationality in those decision makings. Other such systems use neutral factors such as postal code, which unfortunately in practice serve as a proxy for race, exacerbating racial biases and affording a sense of false objectivity to patterns of racial profiling that we know already exist. I can give a few examples. One such example I want to point to is the crime anticipation system that was tested in Amsterdam, which was a place-based predictive policing tool, attempting to predict where crimes such as burglaries were taking place, using a range of different information, including socioeconomic data, but also data relating to the number of non-Western people in a particular neighborhood. Using information such as this system rated areas red, yellow, and green. Red being those areas which were considered high risk and therefore of crime, and such crimes like burglaries, and therefore should have, as a result of this decision, increased police surveillance deployed to prevent predicted crimes from occurring. So all of this, the potential of crime, as opposed to the actuality of crimes existing there. There are a number of other examples of how this plays out in terms of person-based predictive policing systems. So this means various matrices developed to monitoring and collect data on certain types of people, often framed around this notion of gangs or other criminal activity, as was alluded to our previous speaker, criminal activity perpetrated by young people. Given the context of widespread racial discrimination, specifically with reference to our presumed notion of who predicts crimes, we will see that such databases, often where we are able to analyze them, overrepresent Black, Brown, and Roma men and boys, and highlight, therefore, the discriminatory patterns already that we know exist on the basis of rights, of race and class. But also, I think, is not studied enough how far this impact on children's rights. Often these matrices highly impact people under the age of 18, increasing surveillance and also challenging this very notion that we should all enjoy the same level of data protection and privacy. This, although is embedded in our law, unfortunately does not operate like this, and we have this very real problem that we, in reality, are afforded very different levels of privacy depending on who we are, where we live, our race, and our class. I can go into many more details and happy to speak more another time, but I want to say specifically that putting these things in context, all of these technological trends and concerns we might have of certain deployments sit in a context of, at the EU level, where we have a number of proposals to expand existing databases developed for the purposes of law enforcement and migration control. Just this week, we heard that the EU is considering the expansion of the Prüm Convention, which was a database of fingerprints and vehicle registration data, but to include facial data. Inside the action plan against racism, even, there was a line that said that the Commission would explore the feasibility of a similar database as a tool of border control. So all of this is connected. Predictive policing is enabled by the expansion of data collection through such databases, particularly the slow function creep of them. So them initially being used to deal with serious crime and the collection of data around serious crime, but then slowly being expanded to include things like petty crimes. So we know when we have a focus of a system on basis of petty crimes, this will disproportionately impact poor people, working class people, and racialized communities. So all of these raise a number of problems: this notion of pre-criminality, the disproportionality of intervention, particularly on working class people. We don't know many existence of these databases predicting the committal of white-collar crimes, for example, and I think this is a really important, it's not just about how the system functions and the bias within that system, but it's also about what crimes are these are these systems being put in place to counter actually the disproportionality of the targeting of petty crimes and as opposed to very serious white collar crimes or issues such as tax evasion, which, as Chris said, vastly impact our societies much, much more. Then also when we talk about discrimination, it's important not to view this as abstract. We're not speaking just of different treatment and stopping there. No, what we risk with these systems is not only a technical blip or bias that is ultimately insignificant and can easily be fixed, but what we have here is that by design, such systems embed discriminatory conceptions of what crime is, who or which type of people normally commit it. And then on the basis of that, allocate police resources to counter that stuff, which means higher police presence in this certain areas and towards certain people. And in this global moment, if it's one thing that it should have taught us, is that we cannot assume that higher police presence means safety for everybody. It actually means great danger of harm for certain people, cases of abuse, but for some people even death. And so we must take this really very seriously. I'll really be very sure about what EDRI believe that we should be doing about these things. First of all, at the EU level, these issues touch not only migration and criminal justice, but also the issue of discrimination and the regulation of emerging technologies, which is various different EU files. And we really believe that this shouldn't be just framed as an AI issue, but it should be framed and taken into account in the field of people working on criminal justice, but also migration and non-discrimination. And that experts from all of those fields, as well as affected communities, are consulted in anything new that comes up by way of legislation and policy in this area. Secondly, we believe that any upcoming legislation needs to speak to this notion of collective harms. The more we know, we realize that this will be the AI legislation will be a crucial piece of legislation when it comes to discrimination, in that there is a clear gap in existing legislation as to how discriminatory impact against particular groups as opposed to individuals are at stake. The same case with existing data protection law, which very much focus on the individual as the rights holder. But if, as we see, particularly with predictive policing systems, that it's whole neighborhoods and whole groups at stake, how do these systems, how do these legal frameworks that we have apply to that? We also believe that there are a number of governance questions still open, and we do believe that when we have the deployment of such systems in the public sector, in the criminal justice system, but also in many other fields, we do need more of a consideration at a policy level of how do we ensure that people have a say in these things. These are going to be automated decision-making systems which affect our lives. And how do we, as people impacted by those decisions, have a say in whether or not such systems should be allowed to operate? And then lastly, and then I will stop, is that we really argue that the primary goal of legislation must also be preventing harms and protecting fundamental rights before everything else. Before innovation, before the needs of companies, it should be this. And we really think that this upcoming legislation needs to take that into account. With respect to deployments of automated decision-making systems which infringe and even compromise our fundamental rights, we argue that prohibition must be a legal option on the table when such systems have a demonstrated racist impact or are incompatible with human rights by nature or in their operation. The upcoming proposal, we think, on AI must go beyond proposing small technical fixes to systems that, when implemented, will likely engender deeper social, economic, and even potentially physical harms. These harms cannot be attributed to badly functioning technology, but rather that they play a role in a broader system, which I think everybody here has demonstrated. And those systems in themselves are discriminatory, but the risk with these technologies are that they codify these very discriminatory dynamics that we've spoken about today. And with that, I'll stop. Thank you.
Thank you so much, Sarah, for your deep expertise on these issues and for raising, again, this question of what crimes or what things we choose to criminalize and focus on. Fair Trials And I recently conducted some research that shows that, for example, in Germany, over 80% of cases are sentenced with fines. And of those fined cases, something like 25% are a combination of petty theft and fare evasion. Obviously, offenses where the underlying problem is that someone couldn't afford their life necessities. We are now at time, and so we unfortunately will not have the opportunity to go through all of the many fantastic questions that people sent in. We will find a way to reflect on those and try to share some responses. I will, for those that are able to stay a few minutes longer, just ask the MEP one question if she'd like to offer a response to close out our session. We received a number of questions in the chats noting that issues of discrimination and racism are not the result necessarily of specific policies, but that there are deep-seated societal and cultural norms that perpetuate racism in criminal justice systems, for example. And I think many people would love to hear your thoughts on how it is that the Parliament and the EU can try to shift some of those underlying systems of belief. And so we'd love to hear from you if you've got a moment. And thank you to everyone that has joined today.
Okay. So thank you very much for the questions, but I'm just going to answer one question. Yes. How can the EU shift these norms? Yes, that's your question. I think that the first step has been taken because the problem has been acknowledged now. Yeah, and for too long, the doctrine of absolute equality and color blindness prevented the EU from taking action on these problems because people did not want to acknowledge and admit the racism that exists here within our borders. That was the big problem. But now we have the action plan since 1 week. The hard work begins now with the action plan. Education is key to dismantling these norms. People must learn about history of Europe, but also of other continents, history of Africa, of Asia and Latin America, everywhere. Colonialism must be acknowledged, but so must the rich and the deep histories of the areas of European colonized. When I think about Germany, for example, most of the people in Germany don't know that Germany got colonial areas in Africa. When you say that, everybody make big eyes and look at, oh, it's not possible. So the legacy of myself and my ancestors goes far beyond European colonization. Yeah? The member states must be encouraged to acknowledge issues and take steps to address them. We must move beyond the idea that race does not exist and toward the comprehensive collection of transparent equality of data so that we can quantify also the discrimination and address the root causes. Finally, we must listen to people. Too often, as Mrs. Chander pointed out, the burden is on us as racialized people to prove the discrimination we suffer. Instead, the EU must listen to us, and I hope that the new anti-coordinator will be a black person or a brown person or somebody who is racialized, yes, or an expert on racial justice, someone capable of representing us and amplifying our voices. To me, this would be the first steps towards addressing these norms. That was my vision. That's my answer to you. So I am sorry, but I have to leave you. Sorry, I can't stay because I have another appointment. Thank you very much for this wonderful seminar. And thank you very much for all the knowledge I could learn myself. Thank you.
Thank you so much.
To all of those who want to hear more about the use of AI in criminal justice, I just want to give a very quick shout out that we will be holding a specific discussion on predictive policing and some of the tools discussed today in more detail on the 13th of October at 5 p.m. Central European Time. So save the date and look out for details of that on Fair Trial's social media. Thanks very much to everyone for speaking. It's been fantastic.
With that, we will end our session. Thank you again to our panelists and to all of you who attended. As the MEP mentioned in her closing remarks, and as we said in a recent piece in the EU Observer, certainly the people who should be leading these efforts are those that are most impacted. Today, we started a conversation among lawyers and others who joined us from the public, but certainly we need to do much, much more to make sure that these efforts are being led by people of color. Thank you all for joining us again.